Let's talk about collaborative divorce versus litigation. So there's many ways to get divorced. One is what I call the kitchen table deal. The kitchen table deal is you and your spouse sitting at the kitchen table and figuring out how you want to divide your assets and your debts, how you want to share your children, both the decision-making power and the time with your children, and then you're just telling the lawyer all that and they're scribing it. And that is the least expensive way from an attorney's fees perspective. It could be the most expensive way if you don't strike a good deal for yourself. But most people cannot do that for all the obvious emotional reasons, and they don't want to. They would like our assistance. So what are other ways to get divorced? Well, we have collaborative and we have litigation and we have mediation, which is a tool we can use in either of those processes. So collaborative is statutory in Texas. It's allowed by statute. It is a non-court amicable process. It's, to me, the best choice if you can get everybody to choose it. You can only do it if both parties agree. So sometimes one side wants to do it, but the other side doesn't. Sometimes the other lawyer doesn't want to do it, and so then we don't get the option. But if everybody agrees, then we can have a collaborative divorce. Collaborative involves a collaborative team. So both lawyers are trained collaboratively, and then we have a neutral mental health professional and a neutral financial planner. And that's your team for your divorce. Sounds like a lot of people, doesn't it? Well, it is a lot of people, but they all have finite roles. So, for example, without a neutral financial professional, the lawyers are doing the financial aspects. So somebody has to build a spreadsheet of your assets and debts, and when we don't have a neutral, both lawyers are doing that. So your estate is paying 2 times for that work. But if you have a neutral financial, you can just pay 1 time and have a financial professional do it, usually at a lower hourly rate than the lawyers. So they're building the spreadsheet. They're also guiding us in the meetings. So we're having collaborative meetings with everyone at the table sometimes. Sometimes we have a smaller group. And the financial professional is helping us gather the information, understand the financial information, understand things like tax effect, understand what is divisible in certain ways, and then they guide us on the option development of how are we going to divide the estate. So that's the neutral financials role. Then we have a neutral mental health professional. So the neutral mental health professional leads our meetings and helps us with the parenting plan when there are children involved. So the mental health professional has typically a background in child development. They understand different ages and phases and what might be appropriate schedules for children at different ages. For example, you would do something very different with a 2-month-old than with a 16-year-old. A 16-year-old, you could do week on, week off. 16-year-old would do great with that. 2-month-old, not going to work at all. A 2-month-old cannot go a week without seeing the other parent. We're in a bonding phase at 2 months. It's very important for the child to have regular contact with both parents. So the mental health professional will provide information like that and guide the couple in deciding what would the parenting plan be. And maybe it's the same for both kids and maybe it's not. If the kids are very different or if there's a large span in between their ages, maybe you have 2 different parenting plans. So that's the mental health professional's role. Now, some of that occurs what we call offline, meaning without the whole group of all these people. So it might just be the mental health professional and the 2 parties talking through some of the options for the parenting plan, and then they bring it back to the collaborative table with the lawyers to finalize it. Or if they hit a rough spot, the lawyers help to get over that rough spot. So collaborative is voluntary. It is aimed at reaching settlement. It is private. You're not in a courtroom, which is a public forum, very confidential. So those are some of the pluses to collaborative. Now litigation, that's the old standby that we have, and if we can't talk everyone into collaborative, we're stuck with litigation, and it's the court model. We still settle our cases in the court model most of the time. 85% of cases settle, and it looks a little different. We don't typically have neutrals in litigation. Sometimes we do, but not in the way I just described. And in litigation, we gather information, we try to settle, we'll send settlement offers over, we may go to mediation, and mediation is a settlement process where you hire a third-party mediator to help settle the case. And they're not a decision maker, so they're just there to facilitate. And if it doesn't settle, then we go to court, and the judge decides. And the court process is, if you did not settle in mediation or anything else and you went to court, it's very expensive. So most cases settle because people are savvy business people and they do not want to spend their children's college tuition on having a trial. But occasionally cases do have to be tried. And when you are going to try a case, you want obviously the best preparation you can get. And you put on evidence, and that would be in the form of paper, it would be in the form of video if there is any, or audio tape. It's in the form of witnesses testifying. So it's a big deal to try your case to the judge, but that is an option available, and sometimes people do need their day in court, so to speak. So those are the options. There is literature available. I wrote a book about collaborative, so you can read that. It's on Amazon and on our website to help you further understand each process so that you can select the best process for you and your family.